provision, it may not be something that they are totally outfitted for. So I would just ask the court to consider that. Second, the criminal history for Mr. Gordon is relatively less significant than others that we've seen. I would also indicate that the age of the criminal history is fairly older for Mr. Gordon, which indicates that he has stayed out of trouble in recent years. I do understand. I should also mention that Mr. Gordon was screened for recording. Unfortunately, he's not eligible for that. But that is another indicator that all parties here did want to see at least him have an opportunity to show any rehabilitative qualities that he can demonstrate to the court. So I think with all that, plus the possibility of the court entering a suspended sentence, really puts him on notice that if he steps out of line, if he is not compliant with a probationary sentence, he is on notice that he would be going to jail for the full year. I think that would really satisfy all canons of sentencing. So I would ask the court to consider that.
All right. So, sir, are you still living here in Adrian?
Yes, yes, Your Honor.
Okay. Is there anything you'd like to say on your own behalf?
Yes, just like my attorney said, you know, I'm not a troublemaker. I haven't been in trouble, you know, in years, and regardless of what I have going on, I've been to court every time, no matter what's been going on. I've been to court on time. I've missed not one court date. I've never tried to run. Like, I stay right down the street on Hunt Street. I'm not a threat to the community. And yes, I do have health issues on top of the Crohn's disease. I have rheumatoid arthritis. I need an emergency hip replacement, but I've been putting it off because I've had this going on. I didn't know if I was going to go to prison or to the county jail. So I kind of put that off because I didn't want to be in the position to where I just had a hip replacement and ended up, you know, in jail. And that's really basically.
Okay. All right. Anything else?
No, I get, well, no.
Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense. Let me pause here real quick. Are you ready to talk to Ms. McGreen about final jury instructions?
Yes.
All right. So Ms. McGreen, is Mr. Inocencio here?
Yes.
All right. So Ms. McGreen, I think they are ready to put those together. If you wanted to come out and meet with them, the jury instructions are on the table next to Ms. Spade. Your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. So you're on SSI?
Yes.
Okay.
Yes, Your Honor.
All right, so.
Judge, we also have a contempt on this case too for him not drug testing.
Okay, are you willing to test today, drug test today? All right, Mr. Coast, why don't I have Mr. Degger, so it depends on what my sentence is gonna be. So Mr. Coast, could you test him today, please?
Absolutely.
So
if I
we're
could
gonna
just meet
take
him
a
right out in the
pause.
hallway there.
Yep, Mr. Coast to meet in the hallway, all right? Okay, so we're gonna pause on that one. All right, so I have Mr. Malaro. So I have jury back that I need to start closing arguments and jury instructions on. So I'm gonna call the jail. Mr. Malaro, what does the rest of your morning look like?
I have something at 9 o'clock down Judge Morgan Court.
Any from 10 to 11?
I should be done by then.
would it be all right if I put your sentences over, because I had the jury come back, I just need to do closing arguments and I need to do jury instructions.
You're the judge, you tell me when.
Well, I'm asking if you weren't available for the rest of the morning, you know, but if you are, I think, if you want to go take care of Judge Morgan,
Okay,
and then I'll just hold off on your sentencing.
I have a 9 o'clock and it shouldn't take.
That's fine.
Judge, can we put LaFrance at 11? I mean, yeah, can we put LaFrance at 11 then? Because I've got some stuff to do between now and 11.
Yeah, that's fine.
Okay.
Okay, I don't think any of Mr. Malaro, hold on, Mr. Malaro. LaFrance is in person, just so you know.
I know, that's why people.
So do you want to take LaFrance real quick? Because he
We
is in
could,
person.
Yeah,
Yeah, we can do that.
the only thing I have on him is an argument, the guidelines are.
It's probably
lower.
a while. So I get my civil stuff.
Yeah, you know why.
I didn't. see
Yeah,
it.
yeah, you're here on which case?
On roads.
Oh, yeah.
So,
Look,
Yeah, we were
something
gonna
that's like
check.
11 o'clock earlier.
Judge, we were,
OB-19 is the only thing.
I was gonna object to a couple others.
so hold on. So if you want to meet with the other attorney, who's the other attorney?
Shelley Griffin.
If you
She's
want
not
to,
here yet, but she'll. probably-
but the
she'll-
jury room down there is available.
Okay, in the other courtroom?
Yeah, so, we can have someone let you guys back there and you guys can try
Okay.
to negotiate.
Okay,
Okay.
we'll give it a shot. We were
Okay.
facilitating a couple days ago. I don't think, we can talk, but
All
we're
right,
probably not gonna get to it if we don't resolve
Okay.
it till later this afternoon, or
Okay.
11 o'clock or so.
10:30 maybe. I have, jury instructions are not very long for the civil case.
I mean, we're here, we got the day.
Okay.
locked up.
Okay,
Sir, I need your name.
Oh, Joe Milanowski,
Thank you.
on behalf of.
okay. All right, so LaFrance is coming down.
Didn't hold our hell.
No, we still gonna do it. Yep, right, we're doing LaFrance.
There we go.
All right. Who's on LaFrance? Right, Miss Holly,
OB-9 is 2 or more victims. So 2 of them are lost. This one should be scored at 25.
do you want to approach her?
Yeah.
Because otherwise I'm gonna have to put all my sentencings over to 10 o'clock or later.
What am I?
Do you guys agree on some changes to the guidelines?
So I haven't heard anything.
OB-9.
But for the matter of it.
I think OB-19 should be 0.
Would you want to stay?
But I looked at the case law on it and it says that if you
This
run
is not on the
away.
record, Ms. Spade.
Sorry.
Okay, thank you,
If run
Judge.
away or evade arrest, it doesn't count unless the police
Well,
have told you to stop and you run away
So,
from them.
hold on, because I thought that too, see my white out? And then I found, OB-19, right? OB-19, there was one I thought that trial court properly scored 10 points for OB-19 on the basis that the defendant interfered with the administration of justice when he ran from the scene and left the county for 13 weeks to avoid contact with the police, who he knew would want to talk to him with in connection to the offense, and that was People v. Olson.
But I don't think there's evidence he knew they wanted to talk to him about this offense. He was on probation.
He did not make contact with the police yet.
I'm fine, yeah, no, okay,
OB-1 judge, I was going to argue that should be scored as 25, because there's no evidence he shot a person that he
It doesn't.
knew.
It doesn't say he has to know it says he shot at or toward a person, and I would argue, when you shoot at a house, you have pretty good knowledge there could be.
Well, the statement was they shot up my grandma's house, so I shut up their house.
I'm gonna go with, I think, everyone, we're talking about everyone,
Yeah.
or
Obi-Wan.
Obi-Wan. If one offender is signed from precedence, so a firearm was discharged at or towards human being or victim. So I think I wasn't able to find anything that said.
And then number of victims is OB-9.
Yeah, there's 2 or more victims. 2 shot at were in the police.
Was there any testimony to that?
Yeah, it's in the report. So Fresh and Tyndall and then his friend.
Grisham.
Yeah.
Grisham is there.
Mr. Kendall said.
It's-
Hey, Judge,
it's-
he wasn't able to go, so we're gonna try here in another 5 minutes.
Okay, well,
Thank
it'll
you.
probably be another hour, Mr. Daggerman goes in, because I have to do jury instructions and closing arguments on my jury
I
trial.
wrote down the note.
Okay. All right, tell him not to leave my floor. Okay. All right, so
It's still the same range, Sam, it's 19 to 30 days, because this goes to 40 points.
you know what, I'm gonna have to, well, is Miss, I think this is the brain still working, so we agree OB 19 will be 0.
Yeah.
I think OB 1 was properly scored, and what was the other one?
9.
True amount of victims. It's
Yeah.
2 victims.
My sheet.
So it takes OBs to 40, but it doesn't change the guidelines, it's
I
still
think it-
29.
No, I think it makes it move down a range.
Oh,
Yeah, it does the night, I think 19
Okay,
to
so
38.
it's 0 over 40. Yeah, it takes 0 to 17.
No, it should be.
Whoa, wait, oh, PRV 40, I'm sorry, I looked at that, 40 to,
40 and 40 makes it 19 to 30.
yep,
Okay, yeah.
19 to 48, 19 to 38.
Yeah. We're good.
Okay, we're good. All right, and you can put your objection on the record.
Thanks.
All right, Mr. LaFrance,
How you doing?
good morning. Why don't you go have a seat next to your attorney?
No, you're good, just.
Ms. Underwood, Mr. Brigman has zoomed in.
I'm sorry,
Mr. Brigman has zoomed in.
I really don't need to speak with them.
Okay, good. All right, this is in the matter of the people of the state of Michigan versus Anthony Wayne LaFrance. We have 2 files. We have file number 2020-20096 FC and 23-21622 FC. The 2020 file is a probation violation and the 23 file is a new sentencing. I have Salvatore Malaro appearing on behalf of Mr. LaFrance, and I have Allison Arnold appearing on behalf of the people. There was a sentencing agreement at the time of the plea, and that is correctly detailed, I believe, in the pre-sentence report. So, Mr. LaFrance, and you're sitting down, so there's a little microphone, Mr. Malaro. All right, Mr. LaFrance, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Have you had for both files,
Yes, we did.
Okay. the pink one and the white one?
Yeah.
Okay, and you've had an opportunity to discuss with Mr. Malaro and ask any questions you might have?
Yes, ma'am.
Okay, good. Are you picking it up, Ms. Spade?
Just a little.
You got to speak a little bit louder. It's almost like you're yelling at me and you won't get in trouble for it. All right, so Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Yeah, Judge, with respect to the probation report, Mr. LaFrance would like corrected that his father was an Anthony Flores, not a Robert Flores.
Okay, we will make that correction.
I think that was the only correction.
Yes, ma'am.
Ms. Arnold,
No, thank you.
okay. Mr. Malaro, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge, Your Honor.
To your knowledge, Ms. Arnold?
No.
All right, so we've had a little bit of discussion. So on the probation violation report, the guidelines were calculated previously, so we're not going to address those. But on file number 23-21622 FC, on count 1, let me get back to my guidelines. I only had like, well, because the felony firearm is flat too, so there were no guidelines. Do we agree with that? Okay, so then on assault, the count for assault with intent to do great bodily harm, less than murder or by strangulation, the PRVs were calculated to be 40. And Mr. Malaro, you were going to place some objections regarding any of those on the record?
On PRVs?
Mhm.
No.
No, Ms. Arnold?
No, Your Honor, we have an agreement between the parties that, or no, yeah,
Hold on.
sorry,
Okay,
no.
so then the OBs were scored at 50 points, but there was an agreement that OB 19 would be changed to 0, which takes it to 40. But then I do believe you had an objection to OB 1 and OB 9. So would you like to place those on the record?
I would, Your Honor. OB1 classifies aggravated use of a weapon that was scored as 25 points. The firearm was discharged at or toward a human being. The offense itself was a discharge to a home. Mr. LaFrance's own statement in the PSI says someone shot up his grandma's house, so they shot up that person's house. I think that should be scored as best 5. Due to the fact that there's no evidence that Mr. LaFrance was aware someone was in the house and that he was actually intending to shoot at someone in the house. But a weapon was displayed, so I think it should be scored as 5. As to OB9, Your Honor, OB9 talks about number of victims. Again, Judge, we would object to the scoring of OB9 at 10 as to 2 to 9 victims, as again, since there was, his intent was to shoot at a house and not at people, there would be no victims. Not aware that there's anything more than 1 person in the house at that time. I think someone was crawling in through a window, so they were not in the house at that time. So that'd be the basis for our objections to scoring. If those are scored as we suggest, then I think it's 40 and 30, which puts his guidelines at 10 to 23.
All right, any response, Ms. Arnold?
Judge, just briefly, there were 2 individuals in the home, making them both victims. I don't believe there's an intent element on OB1, but to the extent there is, these bullets were discharged at or certainly towards the 2 individuals in the home. And the fact that these bullets were shot at a house, which is where people live, and more often than not, there are people in a home, I think an intent element can be inferred.
All right, well, I will agree with Ms. Arnold. I do believe that OB1 and OB9 were properly scored, OB1 at 25 and OB9 at 10. Only because when you fire at a house, there's a very strong likelihood that there are people in that house and could be shot. In this case, the police report indicates there were 2 or more individuals in the house. So I will leave OB1 at 25 and OB9 at 10, with the total or OBs being 40, and the minimum sentencing guideline range would be 19 to 38. So Ms. Arnold, first I would ask, is there anything you'd like to say on behalf of the people?
No, Your Honor, we just request a court follow our recommendation or agreement.
Okay, Mr. Malaro, anything you want to say on behalf of Mr. LaFrance?
So what judges to the probation violation, looking at the report, Anthony actually was making quite good progress on the probation. He paid down about 1/3, maybe a little more than that of his fighting costs. He was working. I don't think there was any indication he wasn't reporting until this incident happened, and then he, compounded the problem. So we'd ask the court to perhaps revoke and terminate his probation for what he's on probation for. As for the underlying offense for which we're here, again, Your Honor, we ask the court to honor the Killebrew agreement. Mr. LaFrance is a young man. I think he would benefit from certain like anger management issues and learning how to handle, provocation in a better way. I think he would readily agree today that the way he handled someone shooting up his grandma's house, this was not the appropriate way to do it. Let the authorities do their. But, the justice system work its way. I think he voiced frustration in his statement that people that had shut up his grandma's house had been released It caused a lot of frustration for him. So with that said, Judge, we'd ask the court to take that all into consideration, file the killer.
We do agree, because the guidelines are 19 to 38, the agreement was that it would sentence him to the low end of the guidelines, correct? On that count,
The agreement was 2 years on that count. And
with 2 years on the felony firearm,
Yeah.
and then the low end of the guidelines on the other
it was-
consecutive file.
It was 2 years for the firearm judge and 2 years for the
Yeah,
2 years and
pending
2,
case.
24 months, that's what I was trying to clarify. Okay. Mr. LaFrance, is there anything you want to say on your own behalf?
Yes. I wish I was here so I can talk to him in person, but, anything I say doesn't give any excuse for what I did. Just wanna say I'm sorry, both parties could have hurt somebody, obviously. Just let my past, define who I was that day I pulled the trigger. So,
You know, we hear so many reports on the news where, there's a drive-by shooting and a child sleeping on a couch that got shot, or, someone walking through the house that got shot. So we could have been here in very different circumstances today than we are. So in determining or when it happened to your grandmother's house, you know what I mean? It could have either way, but in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence, and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication of the law, and protection of society. On file number, let me get the file number. On file number 20-20096 FC, it's sent to the court that you will serve 573 days in Lenawee County Jail with credit for 573 days, and I will revoke your Homes Youthful Training Act status. On file number 23-1622 FC, on count 1 felony firearm, you will serve the 24 months, and you will get credit for 296 days already served. And then on the count 2, assault with intent to commit great bodily harm less than murder. And it's 24 months.
Yes.
yeah,
You will serve 24 months to 10 years with the Michigan Department of Corrections. This is consecutive to the felony firearm because that's a flat 2. Do you understand that?
yes, ma'am.
And you don't get credit on this one. You only got credit on the other one. Is that correct?
Correct.
Okay. So, there is a $130 crime victim rights assessment fee and $136 in state costs. That's $68 for each count. Is there anything else, Ms. Holly?
I don't think so.
All right, now you do have the right to appeal these sentences. So my bailiff's gonna hand down to you a set of paperwork for each file. And hold on, listen to me. And these are your notice of right to appellate review. You need to initial and date each copy, and then they'll give you 2 copies for each file. If you wish to appeal your sentence, you would fill out the information on the form. You can do it today, or you can do it within 42 days and send it back to the address list on the form, okay? All right, now you can talk to Ms. Millar. Anything else, Ms. Holly?
No, I don't.
Okay, I'm gonna bring Mr. Bergman in. And, all right, so we're going to need Mr. Badger. Who's the prosecutor on that one?
Mr. Harton.
So we will do Mr. Badger, but then the rest of I'm not doing until after my juries come through, okay? Miss Underwood, are you ready on Mr. Brigman?
Yes, thank you, Your Honor.
All right. So, Miss Iddings, you are here on, and Mr. Gross, let me find you guys. I don't know, I thought I had Mr. Gross.
You do.
Oh, there he
Yes,
is.
good morning.
All right, so Ms. Sittings and Mr. Gross, bear with me, all right? So this morning's been a little hectic. So the one thing I could say is I know that you have a judgment of divorce. Do you want to come back at 11? Because I have a ton of sentencings and then we still haven't got my jury back in for closing arguments. So are you both able to bring your clients back in at 11?
I should be able to, Your Honor. I have a sentence books. I have a sentencing at 10 a.m. via Zoom with Judge Horkey out of Monroe, so I should be done by 11. I can let my client know.
I can bring them in and let them know.
At 11.
What, Mr. Gross?
He's frozen. He's frozen.
I have a client meeting at 11 this morning. I do have to meet with client at 11 this morning.
Is there a lot
But I
to
can,
this
for the
judgment
entry of this,
proceedings?
this takes 5 to 10 minutes. So
Yeah, I was gonna say, Your Honor, I can literally do this in less than 5 minutes. It's a consent
Right.
judgment. They've done it. We're not gonna go through every
Yeah.
detail.
Okay.
They've signed it.
All right, so Mr. Gross, you might want to reconnect because you've got a huge delay. Give me 5 minutes and I'll be back to you. All right, Mr. Brigman. All right, so this is in the matter of the people of the state of Michigan versus Brandon Brigman. Let me get your file number 21-20566FH. I have Rhonda Underwood appearing on behalf of Mr. Brigman, and I have Christy Berta appearing as the Special Assistant Attorney General. Says date time set for sentencing. There was an original agreement that sentencing would be delayed, and if it was something about $3,322.91.
Your Honor.
Yes.
If I can interject, I spoke with the Attorney General's office yesterday, and we have a wonderful result today, Your Honor. Mr. Bigman has paid all his arrearages, Your Honor, and he is entitled to the misdemeanor offer, which was, if you paid them all, it would be a misdemeanor disorderly fines and costs. So what I'm requesting at this time is that the court withdraw the plea to the felony attempted child support, Your Honor, and allow us to take a plea to the misdemeanor as appropriate.
All right, Miss Berta.
Yes, Your Honor, that is correct. I believe my office did file the second amended felony non-support info yesterday, adding the count 3 disorderly person non-support, which is a 90-day misdemeanor.
Okay. All right. So Mr. Brigman, I typed your name wrong. I'm sorry. So Mr. Brigman, you've heard the statement of your attorney and the prosecutor or the Attorney General. Is it your wish that I would draw the plea that you entered previously to the felony?
Yes, Your Honor.
All right, so I will set aside that plea at this time. Miss Berta and Miss Underwood, is there any objection to proceeding today to sentencing without a misdemeanor pre-sentence report?
There is no objection on my part, Your Honor.
No objection, Your Honor.
So what did he? So is he paid off the arrearage?
Yes, Your Honor, the arrearage is 0. His obligation of $576 per month continues, but there is no arrearage at this time.
So is there any objection to fines and costs on this?
There is not.
All right, Mr. Brigman, you want to raise your right hand? The other right one. There you go.
Yeah,
Do you
sorry.
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
So, Mr. Brigman, first of all, I want to commend you because I know it's possible you can put your hand down, but
Sorry.
very rarely do people put as much hard work into this as you have done. So one, I'm proud of you, and two, I'm very excited to see someone actually do this. So you've heard the statement of your attorney. Is it your intention today to enter a plea of guilty to one count or count 3 disorderly conduct which carries a maximum penalty of up to 93 days in jail.
I believe so, yes.
Do you
Your
want to
Honor,
plead guilty to the
I just
90-day
wanted-
misdemeanor? Go ahead, Ms. Verda.
I'm sorry, Your Honor, but this is a 90-day misdemeanor.
Yeah, I said it, 90 day. I said 93, but I corrected myself. So Mr. Brigman, is it your intention to plead guilty to that misdemeanor?
I believe so, yes.
Okay, and for purposes of the plea, do we take judicial notice of his prior plea to the failure to pay child support? Or how do you wish to satisfy the elements?
I would say the lesser, the greater for the lesser, and that would be appropriate to take the plea from the previous plea. Your Honor.
Ms. Berta, do you agree with that?
I do, Your Honor.
All right. Now, Mr. Brigman, are you satisfied with your attorney and the advice that she has given you?
Yes, Your Honor.
All right. And we've already discussed that I'm going to do fines and costs. Do you understand that? So there won't be a probation term or incarceration. Do you understand that?
Absolutely, yes.
All right. So do you understand if I accept your guilty plea, there will be no trial? This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you might have for your defense to appear at that trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Judge.
If you are not a citizen of the United States of America, conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've just read to you fairly quickly?
No, Your Honor.
Okay, so sir, how do you plead to the charge that on or about the time period of August 1 of 2020 through March 31 of 2021 and August, well, on those dates that you, in the city of Adrian and the county of Lenawee, that you did commit the offense of disorderly conduct? Guilty or not guilty?
Guilty.
All right, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor, I understand.
In light of the fact that I've already advised on what his sentence will be, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Ms. Berta?
No, Your Honor.
All right, I already told you what I'm going to do. So is it your own choice to plead guilty, sir?
Yes, Your Honor.
All right, so Mr. Brigman, during the time period of August 1 of 2020 through March 31 of 2021, you were ordered to pay a monthly amount in child support. Is that correct?
Yes, Your Honor.
And during that time period, did you pay the exact monthly amount you were ordered to do so?
Yes, I believe. No.
No. Oh,
No,
no, you're here for failure to pay child support. So would you agree that during that time period, you were ordered to pay, I think, $568 a month? And you didn't pay that full amount every month during that time period, did you?
No, I didn't.
All right, are you satisfied, Ms. Berta?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D? Ms. Berta?
The court has.
Ms. Underwood?
It has.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Before the court passes sentence, is there anything you'd like to say on behalf of the Attorney General's office, Ms. Berta?
Nothing further, Your Honor.
All right, Ms. Underwood, is there anything you'd like to say on behalf of your client?
I think the proof is in the pudding, Your Honor. He's done what we asked him to do.
All right. And Mr. Brigman, again, I commend you for doing this. Is there anything you want to say on your own behalf?
No, I have nothing to say, Your Honor.
Right? It's a sentence of the court that you will pay $130 state or crime victim rights fee and a $68 state cost. I would ask that you pay that within 30 days to the circuit court clerk's office, okay?
Judge,
Okay.
Yes.
I'm sorry, is that a misdemeanor? Should it be 75 and 50?
Oh, that's right. It's a misdemeanor. So it'll be $75 and $50. So it's even less. So, Mr. Brigman, we're going to mail to you 3 copies of your notice of right to appellate review along with a self-addressed stamped envelope. I'd like you to initial and date the first copy where it'll be marked for you to do so, and then put that in the self-addressed stamped envelope, put it in a mailbox and mail it back to us just to acknowledge you received the paperwork. The other copies are for you, and if you wish to appeal this sentence, you would fill out the information on those forms and mail it to the address listed on the form within 42 days, all right?
All right, thank you, Your Honor.
All right, and again, thank you. It has to be a huge relief to know that you've done this, and just keep up the good work, okay?
I appreciate that. Thank you, Your Honor.
All right, thank
Good
you.
luck, Mr. Bergman.
All right, so Ms. McGrain, are you done with the jury instructions? Yeah, she's probably still working on them. So Ms. Iddings and Mr. Gross, do any of you have your client with you?
My client's zooming in, Your Honor.
Yep, same.
I have one person zooming in on an iPad. I'm gonna ask them to unmute. Is that
My client, Your Honor, on the iPad Pro, that is Jody Mollinger.
all right? So do I have Mr. Mollinger in the courtroom?
Well, I just
I do
spoke
not.
to him and let him know that the court wanted to do this at 11.
Oh,
So
okay. So your computer was really delayed. So then Ms. Iddings said I can do this in 5 minutes. So I can you see if he'll zoom back in?
yeah, one moment.
Because Ms. Iddings, or you said you couldn't do 11. So,
I have, at 10 o'clock, I have a sentencing with Judge Horkey, and I don't know how long I'm gonna be in that waiting room. Last time I was there an hour and a half. So I
all
might not
right.
be
So
back at 11.
Ms. Mollinger,
He's zooming in
I have
right
a
now.
jury. I had it. I don't even know where I'm from now. So, okay,
Yeah.
because I still have Badger.
Yeah. Yeah. So these are jobs.
Jody, did you say he's zooming in right now?
Yeah, I got
he
him.
said
I got him.
he's trying to get on right now.
Yep. Miss Adams, I don't have the file for Mollinger. I just had my sentencing files. I apologize. I had a trial that went a day longer than it was expected to, and all right, so I've got Mr. Mollinger. Let's see if he's connected to audio. This is in the matter of Jody Ann Mollinger versus Joseph Stephen Mollinger, file number 23-51207DO. I have Adrian Iddings appearing on behalf of the plaintiff and William Gross appearing on behalf of the defendant. This is the date and time scheduled for entry of judgment. So Mr. Mollinger and Miss Mollinger, can you both raise your right hand? All right, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Jody Mollinger
Yes.
and Joseph Mollinger.
I do.
Very good, thank you. Miss Iddings, you may proceed.
Thank you. Jody, is it true that you filed a complaint for divorce with this court on November 9th of 2023?
Yes, ma'am.
You and Joe have adult children, but there are no minor children currently at this time. Is that correct?
We have no children together at all, but that is correct.
All right. When you filed this complaint for divorce, had you lived in Michigan for 6 months in Lenawee County right before we filed?
Yes, ma'am.
Is it true at the time we filed, there was a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood the marriage could be preserved?
Yes,
Is that still true today?
it is.
Are you pregnant at this time?
No, ma'am.
Okay, Your Honor, I believe we already filed, I don't know if you have it in front of you, but there is a consent judgment of divorce that was signed by all parties that my office brought over. So if you don't have it, it's somewhere in the clerk's office. So I'm going to go through this quickly with you, Jody. Is it true, Jody, that you and Joseph, through Mr. Gross and I, came to a complete and final settlement regarding all issues in your divorce?
Yes,
And is it true, in fact, that both you and Mr. Mollinger signed by DocuSign this consent judgment of divorce that we negotiated along with Mr. Gross? Is that correct?
yes,
Okay, and I'm going to hit just some of the things that we need. There will be no spousal support paid by either you or Joe, and that is forever barred. Is that correct?
yes,
The marital home has been sold and the parties are waiting the closing. You're going to be getting all of the net proceeds except for $50,000, which are going to be retained by Joe. Is that correct?
yes,
And any property that either of you purchased after the judgment of divorce is filed is your property separate from the other party. Is that correct?
yes,
Okay, there is a very detailed paragraph in your judgment, and I'm not going to put all this on the record because it's personal and it's financial information. But you and Mr. Mollinger have detailed in great detail, including identifying some numbers of checking accounts, savings accounts, other accounts, retirement accounts, and we have detailed what each of you is going to be keeping in that judgment of divorce. Is that correct?
yes,
Okay, and you had a chance to negotiate that, and both you and Mr. Mollinger came to a final agreement on all the accounts that the two of you owned together or either had in your own name. Is that correct?
yes,
Okay, you're each going to keep any debt that's in your own name. Is that correct?
yes,
You're each going to keep the vehicles that are in your own name free and clear of the other party. Is that correct?
yes,
You're going to sell a few items, a boat and a jet ski, and you're dividing those proceeds equally. Is that correct?
yes,
Each of you has agreed that you're going to equitably divide any personal property that we haven't accounted for. Is that correct?
yes,
Okay, and we also agreed there's some terms about how Mr. Mollinger is going to transfer a certain period or a certain amount of money from his annuity to you within 60 days. Is that?
yes,
Hey,
I'm back. Somebody, somehow I left. Okay, I'll do that again. Jody, is it true that there is a section in the divorce judgment regarding a retirement account sum transfer, and that has been detailed in the divorce judgment? Is that correct?
yes,
Mr. Mollinger is going to keep his military pension free and clear from you. Is that correct?
yes,
You can have your maiden name restored of Pilmore, Pilmore, if you so desire. Is that correct?
yes,
Each of you is going to pay your own attorney fees. Is that correct?
yes,
And you understand that whatever paperwork needs to be signed, whatever follow-up that either you or Mr. Mollinger needs to do, you will cooperate in doing that so that all of the transfers of funds or transfers of titles or anything else that we need, the two of you have agreed that you will do that. Is that correct?
yes,
And if there is any problem with the enforcement of this judgment or any terms that haven't been followed, you understand that this court will retain jurisdiction and we can come back here and ask Judge Anzalone for help in getting those things done. Is that correct?
yes,
And you are asking the court to enter a judgment of divorce today. Is that correct?
yes.
Thank you. Those are the only questions I have for my client, Your Honor.
All right, Mr. Gross, do you have any questions for Ms. Mollinger?
none for Miss Mollinger. I might just ask my client a couple real quick.
All right, you may proceed.
Thank you, Your Honor. Joe, you heard all the terms that Ms. Iddings and Jody went over. just now?
I did.
All right, and were those correct?
They are correct.
All right, and you've entered into this consent agreement voluntarily?
I have.
All right, and you understand, you know, what you're agreeing to here today?
I do.
Okay, no further questions for me. Thank you.
Miss Siddings, any questions from Mr. Mullinger?
No, Your Honor, no questions from Mr. Mullinger.
All right, the court will then find from the testimony given this morning in open court that the jurisdictional requirements for the divorce have been met and that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Therefore, the marriage between the parties will be dissolved and a divorce from the bonds of matrimony will be adjudged. The division of property as set forth on the record is approved. The court will retain jurisdiction over this case until all the terms and conditions of the judgment have been satisfied in full, and the plaintiff may have the use of her former name if she so desires. Ms. Siddings, it's been kind of hectic this morning, so we will make sure to get the judgment over from the clerk's office, and I will sign that today and have it processed and sent back to you. Thank you both, and I wish you both the best of luck. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
All right. So is Mr. Hartung in the court next door? Mr. Dagomar, were you over there?
I was down there.
Okay.
Yes. Jersey.
Is he like in front of the judge or?
They're having issues with an inmate, so they've been back and forth.
Can you?
Go check.
No, you can't go. Thank you, might hire you.
Let's see, how do I do that? Wait.
I have Mr. Campbell zoomed in. Okay. Is he like in front of the judge?
Judge.
Okay. I'm gonna. No, Judge will save her. No. Mr. Malaro, did you just come from Judge Olsavers or downstairs?
Judge Morgan.
No, I don't say. All right, so Mr. Inocencio, Mr. Schroeder. Is there something, Miss McGrain went off to do something to do with something for you guys. So are we ready to put something on the record or are we still waiting?
The only issue that we have, Your Honor, if I may, is we have two jury instructions.
Hold on, let me call the case. Miss McGrain, are you in your office?
Yes, Judge. Also, Judge Olsaver is not on the record.
All right, go get that. No, he can go. Mr. O'Keefe is here for sentencing and it'll take a minute.
You want us to step back here?
No.
Okay.
All right, so, but are you ready, Miss McGrain, on?
Yes, Judge, if you want to let the parties place their arguments on record and then perhaps take a recess.
Okay. Okay, so this is in the matter of in here. Okay, so this is in the matter of Jennifer Lynn Schneider versus Andrew Kelly, file number 21-6614 and Z. I have Bruce A. Innocencio appearing on behalf of the plaintiff, and I have Keith Schroeder, not Thomas Wright, appearing on behalf of the defendant. This is day 4 of a jury trial. When we convened yesterday, or when we finished at the end of the day yesterday, we were going to come back today and do closing arguments and jury instructions. Ms. McGreen informed me that there's a dispute over 2 of the jury instructions, so we can place that on the record, and then when I'm done with Mr. O'Keefe's sentencing, we will come back, and I apologize, it's been a hectic morning. And so, all right, Mr. Innocencio.
No problem, Your Honor. Thank you. Your Honor, Mr. Schroeder and I have been able to agree on all of the jury instructions except 2 non-standard jury instructions, which I have proposed and have referenced in the document that I sent to Ms. McGrane this morning as 33.6A and 33.6B. The only reason I've given those numbers to the proposed jury instructions is for purposes of being able to know exactly where they are in the order of the instructions presented. The first one, 33.6A, relates to the fact that Ms. Schneider moved to an area where a nuisance already existed. And the proposed instruction states, the fact that Ms. Schneider moved to an area where a nuisance may have already existed does not prevent her from bringing a nuisance action or recovering damages for a nuisance. And the support for that instruction is found in the case of Ensign versus Walls, which is one of the cases we provided to court yesterday. Found at 323 Mich 49.
I have it.
Okay, that's the 1948 decision of the Michigan Supreme Court. And in that case, the plaintiff property owners claimed that the business that they conducted, claim that the business conducted by the defendants constituted a nuisance to them and their property. The defendant's business was pre-existing. The plaintiff moved into the area and said, well, we have a nuisance, very similar to what we have here. There's a situation where there is a farmer conducting a business, and there hasn't been a lot of testimony relative to the business activities of the farmer, but we know that he's doing farming in part. The nuisance pre-existed. We heard testimony from multiple people that said this has been an ongoing problem. And we also heard argument yesterday that indicated while Ms. Schneider was testifying, or not argument, I should say, but suggestions that you bought the property as is. You didn't look at a seller's disclosure form, or the seller's disclosure form didn't have a lot of information. That's all true. But the Ensign versus Walls decision of the Michigan Supreme Court, which is 76 years old and has not been overturned, says that you can move to an area where there is a pre-existing nuisance and still bring a claim for and recover damages for a nuisance. Accordingly, we believe 33.6A should be included. With respect to 33.6B, this is an act of God issue relative to the instruction. And what we are proposing is the following. Quote, an act of God is an unprecedented event naturally occurring, which is the only cause of damages claimed by Ms. Schneider. It is Mr. Kelly's burden to establish by a preponderance of the evidence that the damages suffered by Ms. Schneider were the result of an act of God, and the act of God was the only cause of her damages. Mr. Kelly will be liable for nuisance damages if he set in motion the physical intrusion, water trespassing onto Ms. Schneider's property by failing to abate the nuisance. And the support for that is found in Mulhagen versus Allegan County Board of Road Commissioners, cited at 2003 Westlaw 131706.
And that was provided to me yesterday as well.
Yes, thank you, Judge. In the Mulhagen case, it's clear that an act of God defense is an affirmative defense, and it is only to be raised if it's only to be allowed if an act of God was the sole proximate cause. We don't have that here. And in fact, the Mulhagen case, I was shocked when I read this case because it's talking about the transition of a 15-inch stormwater drain pipe to an 18-inch stormwater drain pipe. And the argument in that case was that, well, because of the rain, the act of God, that is what created the problem here. And the argument in this case relates to the fact that, well, there was insufficient drainage. Judge, this is very similar. And even though the defendant hasn't effectively raised an act of God affirmative defense, and there hasn't been much testimony on it, I'm concerned because of the question, one of the questions that the juror raised yesterday in reference to that particular issue. And so just to be clear, I want to instruct the jury that there's been a potential suggestion that an act of God may have been the cause. And I think it's important for the jury to understand that if they believe it might be a cause, it must be the sole proximate cause. And it is the defendant's burden of proof to establish beyond a preponderance of the evidence that that is appropriate. Thank you.
Okay. So I apologize, Mr. Schroeder. We're gonna pause because I have Mr. Hartung and he's a popular man this morning. So I am going to move and so we're gonna break and we'll come back. So Mr. Hartung and Mr. O'Keefe, are you ready to proceed?
Yes, sir. Yes, sir.
All right, let me grab the file. Okay. Yep. Okay, this is in the matter of the people of the state of Michigan versus William Michael Badger Jr., file number 21-20463FH. I have attorney Douglas Hartung appearing on behalf of the people, and I have Patrick O'Keefe appearing on behalf of Mr. Badger. This is the date and time set for sentencing. I do have zoomed in per the email I received, Dave Campbell. I do not have Kelly Campbell, but she might be in the courtroom.
That's David.
Oh, is that
Oh,
David?
Kelly.
Oh, okay. I'm sorry. So I also received a copy of the pre-sentence report. I have victim impact statements from Kelly Campbell, Megan O'Keefe, and then I have character letters from Megan Kiefer, Tamara Hill. I have a letter from Amy Priscilla. I have a letter written by Jody Coden, MA, RDT, CDP, CATP, and the foster mother of Mr. Badger, and Claudian Oakley, a letter. And I have, and the report from Jody Coden. Did you receive all those, Mr. O'Keefe?
Yes, we did, Your Honor.
Did you receive them, Mr. Hartung?
I did, I brought the log on.
All right, so, Mr. Badger, have you had an opportunity to read and review the pre-sentence report with Mr. O'Keefe?
Yes, Your Honor.
All right, and have you had an opportunity to ask him any questions that you might have had?
Not fully, Your Honor.
So you need to speak with Mr. O'Keefe further?
If I could, Your Honor.
All right, so it's gonna be about an hour probably before I can get back, and that's fine. I do have a jury trial that's extended, and I'm gonna go back and let them place the other argument on the record, and then I can take a recess. So if you wanna sit over there, we can have you taken back to lockup to talk about. Okay, thank you. All right, so we're back on the record, and Mr. Hartung, I guess you can go back to where you were.
That is adjourned for a week.
Okay, all right, so we're back with Mr. Schroeder. Response, please.
Thank you, Your Honor. While these two instructions were, or the case law regarding these two instructions were given to us yesterday, we went through all the instructions and they weren't included. And it wasn't until this morning around 3:30 that I received the email from counsel that he is pursuing with these two. With that in mind, I then did have an opportunity to review the cases that were cited by him and the reason why they are not applicable here. The one case, the Ensign case, the 1948 case, was dealing with, and this is why it's so not very similar. That particular case was dealing with the defendants having a business breeding dogs.
It was a piggery.
I'm sorry?
It was called a piggery.
Yeah, well, there's a number of cases that deal with breedings and farming and odors and all of this other stuff. In our particular case, we have a farm field that has surface water running off. And in the Ensign case, they ultimately said, hey, move your business. In our case, you can't say, stop letting the water run down your field from the rain. That's the biggest distinction in terms of the alleged nuisance. It gets into some other things which are perhaps more akin to the other. The other case that counsel had cited, I don't know, he didn't reference it, was the Shanburn case. One, that was an unpublished opinion. Two, in that one, they were dealing with nuisance per se, which we do not have in this particular case. I'm not going to go into all the details because the court has access to that case as well. So that's the primary two specific things why it's not applicable here. While yes, the court said a nuisance, moving into a nuisance isn't a defense, but it takes into particular account the type of nuisance. And both of those cases talk about that. It's one of the things that can be taken into consideration. Let's see. See, there was something else. Again, going back to the ensign, or no, I guess so Shamrock. They were talking about zoning issues and all of these things came into place. And again, we don't have a zoning issue situation. We have rainwater naturally occurring from the water, the rainfall and whatnot. With respect to 33.6, the case cited and argued by counsel, again, is an unpublished opinion. And that was, again, something completely different. In our particular case, we've discussed 10-inch drain tiles, we've discussed 18-inch drain tiles, but these were all underground subterranean drain tiles. In the case that counsel cited, that was dealing with drain tiles were culverts that were put in to take surface water, like into a ditch and put it into a culvert and changing those. And the court argued, well, that changed the amount of surface water, amount of volume of surface water that was then put through by the road commission. Again, a completely different scenario than we have here, that he's arguing we should have abated. But once again, the abatement would have to be, quite frankly, returning the property to its natural state before somebody brought in these structures and then filled in the property. And then actually are the ones that created the issue to begin with by blocking the flow of water, which the court is well aware is something that the subservient landowner can do.
Okay.
May I respond very quickly?
Yes.
Thank you, Judge. With respect to the Ensign versus Walsh decision, which is a published Supreme Court decision, I would point the court to the direction of page 4 and then also page 5. And the very last paragraph on page 4, the Supreme Court was citing a state of New York decision that said, one cannot erect a nuisance upon his land adjoining vacant lands owned by another, and thus measurably control the uses to which his neighbor's land may in the future be subjected. And it goes on to page 5. It says, he cannot place upon his land anything which the law would pronounce a nuisance, and thus compel his neighbor to leave his land vacant or to use it in such a way only as the neighboring nuisance will allow. Judge, from a matter of public policy, if we were to allow people to build something next to vacant property, create a nuisance, then nobody could ever come in and move in near them and say, well, there's a problem here. That's not what the public policy is of the state of Michigan. I would also note that at the very bottom of the first column on page 5, and then into the second column, the court's analysis states as follows. In the case at bar, the trial court came to the conclusion that the nuisance found by him to exist ought to be abated, and that such action was necessary in order to protect the plaintiffs in their rights and in the use and enjoyment of their homes. It may be assumed that new residences will be built in the community in the future, as they have been in the past, and that in consequence, the community will become more and more thickly populated. This means, of course, that the injurious results of the carrying on of defendant's business, if the nuisance is not abated, will be greater in the future than it has been in the past. Such was obviously the view of the trial judge, and we cannot say that he abused his discretion in granting relief. In other words, Your Honor, the Supreme Court found that the trial court ruled exactly as I'm hoping this court will rule, and affirmed the trial court's decision. We're asking the court to do that as well. With respect to the Mulhagen decision, while the Mulhagen decision is certainly an unpublished decision, it cites several Supreme Court decisions, and we're asking the court to rely upon those decisions. The court would review page 2 of the Mulhagen opinion. In the very top of the first column, citing a Michigan Supreme Court decision, Smith versus Board of County Road Commissioners of Chippewa County, found at 381 Mich 363 at page 367. This is a 1968 case, and it states, "We recognize that an act of God is an affirmative defense. However, the defense is only applicable if the act of God is the sole proximate cause of the injury." The court continued, "Here, the intervening event of a severe rainstorm will not relieve defendant of liability where the rainstorm or act of God is part of the very nature of the nuisance involved." And then it is citing Continental Paper versus Detroit, 205 Mishap 404 at page 411, a 1994 decision of the Michigan Court of Appeals. So while Mulhagen is in fact an unpublished decision, it is relying upon 2 appellate decisions that are published, and we'd ask the court to follow that analysis. Thank you, Judge.
Mr. Schroeder, for purposes of the record, could you explicitly state whether in fact the defendant is asserting act of God as an affirmative defense?
Not in that manner, Your Honor. As you heard through the testimony, the resulting water flow, the volume, was due to a torrential downpour. I wasn't going to use actually the act of God phrase in any way.
Okay, all right. Anything else placed on the record regarding this?
No, Your Honor, thank you for the opportunity.
Okay, so I'm gonna have you step back for a moment, and I apologize to everybody this morning. All right, is Mr. O'Keefe ready to come back? All right, so I'm going to what do you have left, Mr. Morrow?
Schumacher and Smith.
Okay, so okay, I am not going to get to Schumacher this morning.
I was gonna ask the adjourn early.
Okay, so this is in the, she's set for 11, you know that, right? Schumacher,
Either way, I was gonna ask.
can you get my mic? Can you come up? 'Cause you don't have it. All right, so we have in the matter of the people of the state of Michigan versus Tiffany Renee Schumacher, file number 23-21338FH. I have Salvatore Malaro appearing on behalf of Ms. Schumacher. Ms. Schumacher is in custody at the Lenawee County Jail. Sentencing was scheduled at 11 o'clock today. Mr. Malaro, you are requesting an adjournment?
Yeah, I don't want to speak for Ms. Arnold, but this was adjourned a week due to numerous sentencing issues that came up, more sentencing issues that, in my opinion, have come up. And I need to talk to Ms. Schumacher more in depth about it, about what to do. And Ms. Arnold, I alluded to that this morning with Ms. Arnold briefly. But that, I was gonna request that, yes.
Well, because I have no doubt that you would be truthful, of course, but is Ms. Arnold willing to adjourn it?
I didn't get that
Okay,
far with the conversation.
okay, so 1 week, 2 weeks?
I'm not here next Friday.
Me neither, I'm at a conference. Miss Adams,
2 weeks would be fine.
Miss Adams, that would be May 16 or 17, Miss Adams?
So 16th, my daughter's graduating.
May 17, Miss Adams?
Sure.
Congratulations.
Graduates from college. Same daughter, same.
So can I do May 17 or no?
Yes, yes, Judge.
All right, so we will set sentencing for May 17 at 8:15 in the morning. You'll get a hold of Ms. Schumacher.
Yes.
Okay, so thank you very much. Ms. McGreen. right, Mr. Schroeder, oh, Mr. Asensio. Did he step out? Has your client been able to provide a sample, Mr. Dagmar?
Yes,
All right.
yeah,
Okay. All right, so, all right, so Ms. McGrain has provided to me the jury instructions that, I'm going to, based on the arguments used today. So non-standard jury instruction 33.6A will state that the fact that Ms. Schneider moved to an area where a nuisance may have already existed does not prevent her from bringing a nuisance action or recovering damages for a nuisance. And we added, however, it is a factor that you may, you may consider in determining whether Ms. Schneider is entitled to damages, and if so, what damages are appropriate. 33.6B, based on the arguments I believe is correct, and I would side with the plaintiff in this matter, based on his arguments. An act of God is an unprecedented event naturally occurring, which is the only cause of damages claimed by Ms. Schneider. It is Mr. Kelly's burden to establish by a preponderance of the evidence that the damages suffered by Ms. Schneider were the result of an act of God, and the act of God was the only cause of her damages. Mr. Kelly will be liable for nuisance damages if he sets in motion the physical intrusion, water trespassing onto Ms. Schneider's property by failing to abate the nuisance. So I'm going to add those to the book, and then counsel, do you need opportunity to review all the jury instructions again?
No, I will need copies of those two instructions.
All right, so Miss McGrain, could we print off those two? And you guys, oh, so I do have a verdict form that's approved by both of you.
Yes.
And did you guys initial it?
Yeah, we did.
Okay, so, yep, I have that. So I do have a couple more sentences, so I'll be with you shortly. All right. So, Miss Adams, I don't see Mr. Coast or an email regarding, Miss Adams, if you could call Mr. Coast on Mr. Gordon.
Okay.
All right, so do I have anything else with you, Mr. Malone?
I have Emily Smith, she's a president.
Okay, okay. She didn't get brought over though. All right, so. All right, Mr. Badger, you wanna step back up?
Okay. Adjust the mic, please. Okay, thank you.
Probably more for Mr. Badger. Attorneys tend to be loud, clients do not. All right, this is in the matter of the people of the state of Michigan versus. Hold on. Versus William Michael Badger Jr., file number 21-20463FH. I have Douglas Hartung appearing on behalf of the people, and I have Patrick O'Keefe appearing on behalf of Mr. Badger. We're back on the record in this matter. Thank you for your patience. So, Mr. Badger, have you now had enough time to speak with your attorney?
Yes, Your Honor.
Okay, good. And make sure you speak up so we get a good record, okay?
Yes, Your Honor.
Are you satisfied with Mr. O'Keefe as your attorney and the advice that he has given you?
Yes, Your Honor.
All right. Mr. Hartung, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
No, Your Honor.
Mr. O'Keefe, do you wish to?
Just a couple slight modifications, Your Honor, under it indicates the defendant has.
Could you speak up, please?
Yes, under physical health, it indicates that Mr. Badger has suffered from hypertension that he began treatment in March 15th of 2024. That should actually be March of 2021.
All right, so Mr. Moore,
Yes.
can we change, oh, wait, so Mr. Moore, under health on page 8, hypertension treatment began, and state the date again.
March 2021.
So that date needs to say 2021. Thank you, Mr. O'Keefe.
The same would apply to the diabetic row directly beneath that.
Okay.
So he started treatment with insulin in March of 2021 as well.
Okay, very good, thank you. Any other things?
As far as his assets, Your Honor, on page 9
Yes, sir.
of the report, it indicates that he has a house. It's worth $135,000. I believe he sold and closed on that house. Is that correct? Yes. Okay.
Did you?
So he sold and closed on that house, so that would indicate that should, I guess, just be stricken under the asset section where it says house.
Okay, so.
Your Honor, that would have not been sold at the time
Right, I understand
Oh,
that.
yeah.
So he does have the asset of 135,000 that the house was sold for. So we can change that to state that that home has been sold. Okay,
And I believe the mortgage is no longer in place as well under liabilities.
yep, so,
Maybe the last one came
Yes.
in April.
okay, so we will strike that.
All right. Other than that, Your Honor, just a couple of challenges in scoring. the guidelines.
Okay, I'm not there yet. So, in this case, I show he has no prior record, juvenile, misdemeanor, or felony. Would you agree with that?
Yes, Your Honor.
Okay, so, Mr. Kelly Campbell, so, I'm gonna mute you just for a moment, and then I will ask if you wish to speak, just because we're recording and I need to keep, a clear record. Miss Lucas, are you here for the Badger sentencing, or, yes?
No, I'm not. I'm here for the Todd versus Todd.
Okay, I don't know when that's going to be heard today or not, so I'm gonna put you in the waiting room. All right. Okay, so, do you have any challenges to any of those questions, Mr. Hartung?
No, Your Honor.
Okay, so the probation department has computed the minimum sentencing guidelines on operating while intoxicated causing death to be 36 to 71 months. So Mr. O'Keefe, starting with PRVs, do you have any challenges to the PRVs? They're
Yes, Your
0 or they're 10?
Yes, Your Honor, we do have a challenge to PRV 7, which is scored at 10 points for subsequent or concurrent felony convictions. As the court is aware, the defendant was convicted of reckless driving causing death and also simultaneously with operating while intoxicated causing death. Although Mr. Hartung has in the past correctly pointed out that the defendant can be convicted of both of those offenses, even though they're part of a single transaction under People versus Friedel. I would agree with that contention. I would agree that the defendant can be sentenced, can actually be convicted of both of those offenses. However, Michigan Constitution, Article 1, Section 15 is the double jeopardy clause under the state constitution, and it prohibits multiple.
So I'm gonna pause everybody here. How many objections do you have to the guidelines?
2.
Okay.
PRV 7.
Mr. Hartung, were you aware of these in advance?
No.
Okay, so I'm going to have to adjourn the sentencing. I'm gonna ask that you write a sentencing brief, okay, so that I can research that as well and allow Mr. Hartung the opportunity to do so.
Okay.
All right, so Ms. Adams, June or May 17 at 8:15, or is that morning heavy?
That's a bad day for me.
Okay. So, Ms. Adams, when, we could do an afternoon too. Ms. Adams, could I see the book?
Sure.
Only because Mr. O'Keefe, I think it's important that we have a sentencing memorandum and have the opportunity to fully look at that, so a correct decision is made. So, I'm gonna need time to write that. Mr. Hartung will need an opportunity to respond. So. Can do 1:30 on June 5.
I'm supposed to have a trial that day.
Okay. Then I am out of the country. So I can do Dennis Clark. Dennis Clark is still on trial. I can do Thursday, June 20th at 8 a.m.
Yes, Your Honor, that works.
Mr. Hartung?
June 20th at 8?
Yep.
Yes.
All right, so we're going to adjourn this to June 20 at 8 a.m. And then Mr. O'Keefe, just provide a copy of that, probably in the next 2 weeks to Mr. Hartung and the court. And then Mr. Hartung, I would ask that you respond within at least 2 weeks of that. And then we will see you back June 20 at 8 a.m. and you want to be in person, right?
Yes.
Okay, so, all right, we'll see you back on that day. Thank you.
Thank you, Your Honor.
Adams, I do have a big stack if you want to come get it. Okay, so, I have Lee Heiss. Ms. Underwood, Mr. Malaro. I do not have Darren Coast. Let me see.
I'm right here. Darren just walked in.
Oh, okay. All right, so Mr. Gordon, find your file. Jury instructions. Davis. I'm not sure. Miss Adams, did
I don't think you
send back?
One.
Did I send Gordon back, Miss Adams? Nope, I got it. But I do have a big stack if you want it. All right. So stand at the podium. Okay, with this. All right, so we are back on the record in the matter of the people of the state of Michigan versus El Hassan Gordon. Mr. Coast, were you able to test Mr. Gordon?
I did, Judge. Prior to the test, I asked him if he's taking any medications. He stated no. Was positive for Suboxone. I asked him again. He says, well, I may have this prescription at home, but I kind of use it on or off and on. But I've never received a copy of that prescription.
So he wasn't positive cocaine, methamphetamine?
Just the Suboxone. No, he did have a initial test back on April 2nd that was positive for fentanyl. But since then, we had 0 tests. He's missed a minimum of 5 tests after that.
Okay. All right. So when we stopped, you were asking for a term. I think we got through the sentencing and you were asking for a term of probation from the court and you were making your statement. So is there anything you wish to reiterate?
Well, Your Honor, I guess just to address the new information of the testing, obviously, if Mr. Gordon has that prescription, he must provide it to Mr. Coast or whoever the supervising agent would be, if the sentence would be probation. Additionally, with the missed tests, he's going to have to straighten that out. And again, that's even more of a reason to have a suspended sentence, is to make sure a probationer is compliant. And they are on notice that if they do not comply, then it's no fault except that individual for non-compliance. So I think with that, my request remains the same for probation. And if Mr. Gordon has any further allocutions, sir.
I'm ready. Mr. Malawi, you're ready for Davis too?
Is Dr. Zito?
No, Miss Underwood, you're ready for Davis? You know he's here in person, right? Okay, all right, so, Mr. Gordon, anything you want to say on your own behalf? No?
Yes or no?
No, Your Honor.
Thank you.
Okay, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation on the probation department, as well as what has been set upon the record at this hearing, the criteria and reasons for the sentence, or the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, potential for reformation, vindication for law, and the protection of society. So, Mr. Gordon, Mr. Dagger-Margosian made several valid arguments regarding that your history is older and that you have stayed out of trouble for a period of time before these offenses occurred. But it's clear that you know, you have not tested as I required, and that is concerning to me. So what I'm going to do is place you on probation for a period of 12 months. During that term of probation, you're not to use any illegal controlled substances. You are not to use Suboxone until such time as you have provided a valid prescription for it. And I want to know that you're in treatment and just not randomly taking it, okay? You are to comply with all drug testing requirements. Failure to do so could result in incarceration. I will order you serve 12 months in Lenawee County Jail, but I'm going to suspend that. But if you violate probation, you're going to serve 12 months in jail. You got it?
Yes, Your Honor.
All right, and I'll give you credit for 9 days. I fully understand the severity of Crohn's disease. My best friend had it, and you know, and it is difficult, but I'm going to leave that up to you on whether you go to jail or not. Let's see, Ms. Teskey, I'm not going to do an alcohol clause. I am you're on SSI, so I'm not going to order that you stay employed. What else would you like me to order, Ms. Teskey?
Your Honor, I would like you to order, he is not to use any type of controlled substance. He is to comply with the requirements of drug testing. He is to
search and seizure.
Provide the probation department with any prescriptions that he has.
Yep.
He has to engage in treatment. He is to allow search and seizure of his house and any property. So that's himself, his vehicle, his home. Let's see, what else do I normally order?
I'm not ordering the alcohol clause.
That's okay.
Okay, so you understand, can't use any illegal controlled substances. If you have anything that might be a narcotic prescription, you have to provide that to Ms. Teskey. You have to drug test as required. You have to do treatment counseling if she orders it. If they believe you have anything that would violate the terms of your probation, they have the right to search your house, your car, your computer, your phone. You got it? So I'm giving you that opportunity based on your attorney's arguments today. Now, I am going to, because you're on SSI and indigent, I'm going to order that you pay $130 crime victim rights fee, $68 in state costs, $60 DNA fee, $30 per month supervision fee, 130, 68, 60, $30 a month supervision fee, 60 if we need to put a tether on you. There's no restitution. I'll give credit for 9 days already served. I think that covers it all. And you're to obey and comply with all other provisions of your articles of probation that might be added, okay?
Sure.
So you weren't testing for me with Mr. Coast, okay? But if you don't test for me with Ms. Teskey, you're gonna do a year in jail. Got it?
Yes, Your Honor.
All right. Now, you do have the right to appeal this sentence. My bailiff's gonna hand down to you your notice of right to appellate review. We're gonna have you initial and date one copy for our records. Yeah, look at me. The other copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. So initial and date one copy, just so I know you got it. And Ms. Teskey, you want him to report next Tuesday morning between 8 and 10?
I do, Your Honor.
All right. And is Mr. Davis being brought?
Just have to, yeah.
Okay, so bring Mr. Davis down. There it is. All right, so Mr. Gordon, next Tuesday, report between 8 and 10 across the hall, all right?
Oh, good.
On the 3rd floor. All right, thank you.
Thank you.
Thank you, Mr. Dagmar goes in. Okay, so that got adjourned. So Becky, could you call the jail and get Miss Smith? So Mr. Davis, go stand up there with Miss Underwood and Miss Adams. I think I gave you Emily Smith's file. So I'm talking to Miss Adams, my chaos coordinator, Miss Adams. All right, so this is in the matter of the people of the state of Michigan versus David James Davis, file number 23-21633FH. of Rhonda Underwood appearing on behalf of Mr. Davis. Mr. Davis is present here in person. Jennifer Walsh has zoomed in from the Michigan Department of Corrections. So, Mr. Davis, have you had an opportunity to read and review the pre-sentence report?
Yes, ma'am.
Have you had an opportunity to speak with Ms. Underwood about it?
Yes, ma'am.
Are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
All right, Ms. Underwood, do you wish to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report?
We do not, Your Honor.
All right, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? I show he has a juvenile record. I show he has 12 prior misdemeanors and 6 prior felonies.
It does not, Your Honor.
All right.
Not that we're aware of.
Let's see, the probation officer computed the minimum sentencing guideline on charge 1, count 1, which is a felony, to be 2 to 17 months. Do you agree with that computation of guidelines?
I would agree with that.
Before the court passes sentence, is there anything you'd like to say on behalf of your client?
Briefly, Your Honor, I think Mr. Davis has used this time in jail very wisely. He's gotten his head together. He's discussed with me a number of issues regarding taking responsibility and getting his outstanding warrants cleaned up and going on with his life, Your Honor. He very much desires to do that. I understand the recommendation is for no probation in this matter. I think that's totally appropriate, Your Honor. I also understand that the recommendation is for a year in the Lenawee County Jail with credit for the 180 days he has served. I would ask the court to consider, Mr. Davis is probably going to be incarcerated in multiple jurisdictions before this is over, Your Honor. And I would submit that the sooner that happens, the better, Your Honor. So I would ask the court to consider something less than 12 months, because I think the sooner Mr. Davis gets these matters resolved, the better for society and the better for Mr. Davis.
I show he has a felony possession out of Washtenaw County, and then he has quite a few felony charges or parole violations or probation violations out of Tennessee. So, and Florida. So you're definitely a wanted man right now. So is there anything you want to say on your own behalf?
I just want to apologize to Ms. Frost for her inconvenience and to this court for being here. This is not smart.
Well, I appreciate that, but that's our job. We wouldn't be here, wouldn't have a job, but you should apologize to yourself, because you're going to spend a lot of time going back between Florida, Tennessee, and wasting a lot of your life. All right. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence on the nature and gravity of the offenses, the discipline appropriate to their commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. You know, sir, I really hope you take care of this and change the path of your life. Because otherwise you're gonna spend a great part of your life in prison. So it's a sentence of the court that on count one, well, they're both one, okay. So on count one, motor vehicle unlawful use, and count two, lying to a peace officer, that you will serve 12 months in Lenawee County Jail, give you credit for 180 days. You'll pay a crime victim assessment fee, $205, that's $130 for the felony count, $75 for the misdemeanor count. State costs are $68 for the felony count and $50 on the misdemeanor count. That's $118. I'm not going to put you on probation. Obviously, you can be released to head off to wherever you need to go. And anything else, Ms. Walsh?
We need a DNA.
Oh, well, he was on probation with you. Didn't he already pay one for that within the last couple of years?
Probably. I wasn't sure.
Yeah, I mean, if he was on probation with you, they probably did a DNA fee on that one. So I'm not going to assess that. So, Mr. Davis, you do have the right to appeal this sentence. My bailiff's going to hand down to you 3 copies of your notice of right to appellate review. You're going to initial and date 1 copy for my records, just to acknowledge you received the paperwork. The other copies are for your records. If you wish to appeal the sentence, you would fill out the information on the forms, mail them to the address listed on the form within 42 days. All right? All right, thank you.
Your Honor,
Miss,
I'm not gonna see my fiance for quite some time. Can I possibly give her a kiss before I leave this courtroom?
Mr. Frost is giving me a side eye. I don't think we're allowed physical touching. So I wish I could. You can blow her a kiss, tell her you love her, but we can't let you touch. So, Ms. Adams, did you hear from the jail, Ms. Smith? All right, good luck to you, Mr. Davis. The record should reflect, I received back a signed copy of the notice of right to appellate review. All right, so Ms. Underwood, thank you for your patience this morning. Sure. And then, Ms. Adams, did we hear from Ms. Smith at the jail?
Judge, they are getting her, yes.
Okay, so, Ms. Fullerton, Lee Heiss, and I have the paralegal for, the DHS prosecutor. But, are we just getting a date today?
I think Miss Hennigan wants to make an argument about progressing today. She has some witnesses called. She's there in person. Is she there in your courtroom, Judge?
I'm not gonna be able to do that today, so we're just gonna have to adjourn this. I have a jury trial that's gone over to day 4. And I had, I don't know, 8,000 sentencings this morning, so we're gonna have to get another date for this.
I think it's appropriate for some mediation even, but we'll deal with that another time.
You're in person. Okay.